Good morning to all of you. This video is intended for the professional ethics students, that final year students. We are going to discuss the question paper number 2015. Right. Question number 15. X, an advocate, taking advantage of the situation of his clients who were facing death sentence, obtained power of attorney from them and sold the property of the clients and misappropriated them for his personal gain. Right, on a complaint made by the clients, the Bar Council of India removed his name from the rolls of the Bar Council as a sort of punishment. Right. So now he challenged the order of the court as unconstitutional. Decide. I think I told very famous case, P.D.Gupta. I have told that case to you. Anyway, let us discuss once again. 2013, 2011. 2012. Oh, luckily I did not tell you 2015. Okay, right. So here, please remember, the advocate taking adverse situation who are facing. So already he represented them, he argued the case, but the case ended in conviction. Therefore, they have to take jail, go to jail. That too, they were sentenced for life. No, sorry, they were sentenced to death sentence. Right. So, since a lot of properties are there, so he wanted to grab the same. Of course, they are also willing to spend some property for going on appeal. Right. Whatever it is. So, he obtained, they gave him GPA, that is General Power of Attorney. He took GPA from them and sold the property of the clients. Please remember. And misappropriated the same for his personal gain. So, this was later loaned to the clients after coming out on bail, and therefore they have put in a petition or a complaint to the State Bar Council. The Bar Council, so as per section 35 of the Advocates Act 1961, they took up the matter, they formed a disciplinary committee. The disciplinary committee conducted the inquiry under the provisions of CPC. Ultimately, it came to light that this man has misappropriated the property. Therefore, they recommended for the removal of his name from the records, from the rolls of the Bar Council. Now, he is challenging the same. Of course, he can challenge the same before the Bar Council of India, or he can challenge the same before the Supreme Court also. Now the matter has come. Now, what are you going to decide? Suppose if you are a judge, what are you going to decide? So please remember, yesterday itself in the class we discussed that advocate should not lend money to the client. Advocate should not purchase money or choose to purchase the property of the client, particularly when the property is in litigation. That means when the matter is sub judice. When the property is an actionable claim in a civil suit, definitely you cannot claim or you cannot purchase the same, because it's a matter is pending. And secondly, the important point is that please remember, if you deal with the monetary transactions, definitely there will be a financial connection between you, and it is against to the ethics, Bar Council of India ethics. So please do not purchase any property, maybe India, okay, right, 34, shall not negotiate with any party, anytime acted for a party, accountancy, whereby you will adjust the fee payable. Okay. Rule 22. Advocate should not directly bid or purchase either in his own name or any other name. So please remember, this is the rule. Okay. Then, okay, other things are there. This is the best case law. Right. So, a very famous case law is P.D.Gupta versus Murti, 1998. You can see it SC 383 page number also. Right. P.D.Gupta was practicing in Delhi. Right. He was the legal counselor for vodyawati, who claimed the property of the great man, that is, I do not remember his name, Kishan Das. Yes, his name is Kishan Das. So she stated that she was the successor of Kishan Das, late Kishan Das. So therefore, vodyawati through this P.D.Gupta, he filed a case under section 276 of the Indian Succession Act claiming the property of Kishan Das. that too prime property located in Delhi. Right? This was objected to by the we can say the real successors, Mr. Ramurthy and others. Now the case is going on. So Ramurthy claims to be the real successor, and he filed a case on Vodyawati also. So when the matter is sub judice, what happened? This P.D.Gupta purchased the disputed property for 1.8 lakhs. So please remember, this is in 1998. So before that, 1995 maybe. So he purchased the property for 1.8 lakhs in the year 1982. Right? The property is located in Daryaganj, Delhi, and he sold it to a third party. So ultimately, please remember, actually, who is the third party? He is the son-in-law, Mr. Suresh Kumar Gupta. He purchased the property. He is the third party, definitely. Since he is not the lawyer, critically. Now, when the matter was complained to the Bar Council, definitely purchasing a property itself is illegal. Number two, disposing the third party. So, highest form of misconduct. So, taken as misconduct, and please remember, under Rule 22, the disposal was taken, Section 35. You may be knowing their names were removed from the list. His name was removed from the list of advocates. Very serious case, important case also. Second case, D. Sai Baba versus Bar Council of India, and another 2003. Actually, this Sai Baba was a physically handicapped person at the time of studying of law also. So in that physically handicapped quota, he got some STD booth. So 2000, maybe in the year 1997 or so. So he got some connection, STD booth. So we used to go there, give some money. Then we used to talk trunk call. Previously, we know our situation was very different. When we had to book trunk calls, we had to wait there. From that situation, this STD booths have facilitated us very much. Of course, now since cell phone has come, you do not know. So STD booth was there, and he was allotted in the physically handicapped quota. Okay. Then he completed law. He married one Anuradha on 4/12/97, and he has actually his wife is looking after the same because he is enrolled as an advocate. He is looking after the profession, right? So till he became the lawyer, he was sitting in the STD booth, and he was running the booth. And in the meantime, his father also retired, and he came back. Both his father and his wife, they were looking after the STD booth, right? So somebody, those who are not in favor, they have put in a petition against him. Then the Bar Council of India, Council of the State, they received the petition, they called him and they warned him, Are Baba already have been enrolled as an advocate. Right now your wife or father are looking out of him. So you surrender the same. So the STD booth should not be in your name. If it is your name, you are personally engaging in business. Rule 36. You are personally engaged in business. So better you leave it. So okay. Then he said actually the Bar Council has cautioned him to surrender the booth before 20/2/2001. But of course he could not do it. He could do it on 30/3/2001, 1 month. So there's no much this thing. But anyway, his name, he was suspended for 2 years. Please remember. Why? Because he could not do it within the prescribed time of 20/2/2021. Of course, the Bar Council of India also supported the Bar Council of concerned state. Ultimately, he filed the appeal. In the appeal, he was successful, of course, because he was number one, physically challenged boy, and secondly, he has surrendered it. Of course, there was delay. We can't help the delay because date prakaram jaragante kaadu kada. These two are the good cases. But anyway, purchasing a property or having the property at the time of which are the so-called in litigation, you cannot do that. It is against to Rule 22 and Rule 36. Since occasion has come, I have mentioned that also. An advocate should not personally engage in business or thing. So already 9 minutes are over. So thank you very much. So such typical cases, if at all they come to my notice, I will be making video. So please see the video. I think your examinations are at the 19th or so. So better you hear the same once or twice, and definitely it will increase your legal knowledge. Thank you very much.